here for the
I'm happy to be on it, and I do support
it. Okay, I can add him. All right, so good morning, Michelle Childs, Office of Legislative Counsel, and we're taking a look at an amendment to H72 related to overdose prevention centers, and you should have a copy of draft amendment 2.1 in front of you. And so you recall that we were just looking at subsection C of section 1 related to the immunity provisions for an overdose prevention center. And you have proposed, and because the committee doesn't have jurisdiction of the bill, it's going to be individual instances of amendment. And so you're just making one proposal of amendment that if you're looking at the copy that came out of Health and Welfare, which is what you'll be amending, and you take a look at subsection C, which starts on page 3, the introductory language. And I'm just going to read the intro language for you as a reminder. So the following persons are entitled to the immunity protections for participation in or with an approved overdose prevention center that is acting in the good faith provision of overdose prevention services in accordance with the guidelines established pursuant essentially to the Department of Health. And so I've added this new subdivision 4, just kind of like refer to kind of belts and suspenders language to make sure something's perfectly clear, is you'll see that the immunity provisions that are provided in this section do not apply to an individual who's using the services of an overdose prevention center if the basis for a civil claim is that the person operated a motor vehicle in violation of our impaired driving statute, or claims unrelated to the provision of overdose prevention services. So that's kind of to address, Senator Sergio brought up the issue around a slip and fall or something like that. That's not directly related to the services that they're providing.
The fact that something was, steps were slippery or whatever.
Right. And that's it. And so what I can do, if you approve this amendment in context, I'll add Senator Baruth on that. And then.
Yeah. Did you want to go first, Senator? Or you want me to go first?
For the amendment?
Yeah. Because whoever goes first reports the amendment.
I'm happy to go first.
Okay.
Unless you had a preference.
No, I don't. I don't have a preference. I just. It's basically common sense. If somebody left the bar, we wouldn't give them immunity from DUI because they left the bar. And we wouldn't give somebody immunity, the bar owner immunity, because he or she kept a shoddy place.
I think that makes sense. I think, are there, I don't want to open up a can of worms though, but could there be questions about other potential civil claims that could arise from a connection to someone having previously been at an OPC? Which I know is a very broad question, but.
Right, so nothing was presented to me in that context, but I'm happy to, if you want to, before the amendment goes on the floor, I'm happy to chat with you a little bit more on the floor.
Check the central lines and go into health and welfare tomorrow.
Okay. I'm happy to keep it as is then.
I think it meets that if it has nothing to do with overdose prevention services, and you're not immune from that slip and fall or any other behavior of the landlord.
If you look at the lead-in language,
you're giving the landlord immunity as well in this bill.
So what page was the lead-in?
If you have the same version as I do, page 3 of the Health and Welfare Amendment, and you look at subdivision C1 for the lead-in language, it's the protections are related to the provision of services. So I realize that your question could still relate to the exact provision of services, but I'd have to, this language is modeled after Rhode Island, I believe, so we were looking to other states, and there's nothing that we saw in other states in terms of that they had something that was perhaps, more detailed around exemptions or anything like that.
Yeah, so the way I'm interpreting it is that this is that for the amendment, it's a very clear exception to the immunity provisions, whereas other areas would really just be up to the facts and circumstances as the
Right.
judge or the jury decides.
Right.
Okay. Thank you.
Mm-hmm.
Okay, so all 4 members who signed on to it
Okay.
are okay with it?
So I'll do Senator Hashim first, and then I'll do alphabetical for the
Yeah.
rest of those, and I'll do a new version, and I will send it to Ben and Senator Hashim.
And Ben, would you send a copy of it to Senator Lyons and the assistant over there, whomever that might be?
Oh, yeah. So Ben just told me that they wanted me to go in now.
Oh,
They
Or
want,
no?
yeah, so as soon as this is wrapped
so
up, they
Senator
want.
Hashim won't go in, you?
They asked for Michelle and Senator Sears, because I think they thought that it was a Sears amendment, but if it's now Senator Hashim's amendment, I'm
Yeah.
sure it would be okay with.
Yeah, sounds good. Tomorrow?
They actually said today, right after we're done, before 12 o'clock, hopefully, which we are, so.
This is a little less controversial than the last issue you spoke on.
Yeah, we'll see. We'll see.
So should I make those changes to it and then send it to all of you, and then I'll
And then go,
come
yeah,
grab Senator Hashim?
that
Does
would
that
work.
does that work for
Yeah,
you?
that works.
And I'll
Thank you.
tell Kiki that.
Okay.
Okay, Eric Fitzpatrick is the next show up here. Show up here.
To roll into the committee.
Wow. Eric, good morning. Our first item for you is the proposal of amendment back to the House on S-209.
Right.
Concur with further proposed amendment. And Senator Baruch has been in conversations with Representative Long. And, another name I don't know. So, would you want to, either you or Senator Baruch want to go over it?
Okay.
Why doesn't Eric go ahead and explain this, and then I'll talk about where it might diverge from what I discussed with Senator or Representative Lowron.
Sounds great. Morning, everybody. Eric Fitzpatrick with the Office of Legislative Counsel, here as the chair said to walk the committee through the Senate's proposed amendment to the House proposal amendment on S-209, Act relating to unserialized firearms and unserialized firearms frames and receivers. With the yellow highlights, you'll see these are the changes that the Senate has proposed to the House amendment that came over. So I'll walk you through those pretty quickly. The first few pages are really all the same topic, starting on page 3. You remember the bill that came over from the Senate, that you passed out of the Senate originally, had a criminal offense for both possession, transfer, and manufacture of these unserialized components. It was a misdemeanor for first offenses, and it progressed up to a felony. What the House did was it proposed to make possession a civil offense. Remember, so it kept the structure the same for transfer and manufacture, but it broke out possession and made that a graduated system of civil offenses rather than criminal. So what you see in front of you is what I think the committee agreed on, which is to go back to your proposal originally, which was not to have a civil offense for possession, but to keep your tiered structure of misdemeanors instead. So that's what's going on page 3. That's just reverting to your language. Page 3, page 4, page 5, page 6, well, no, 6 or something. So page up through page 5, that's what is happening with the highlighted version. Although not highlighted, because it's not here, you did agree to, in several places, just as an example, page 5, line 6 is one example, the exemption that you had for when someone possesses or transfers a firearm, unserialized firearm for the purpose of getting a serial number put on it. Remember, you struck, so the House proposed striking the word temporary, which you agreed to, and so that doesn't appear in front of you.
And so I can add in here that it seemed to me the only real point of disagreement with the House would be over civil versus criminal. So we talked about it, and one possible compromise was to take their idea of a civil penalty for the first offense and then move to criminal penalties for the second and the third. And I know that's not what this says, but that was something that Chair Lalonde believed that his committee could agree to.
I don't like it, but I can accept it. But that's just for possession of the weapon, it's
Yes.
not for trading it or
Yeah.
using it, and the commissioner will come on.
So in other words, if somebody's being, charged for a second offense, it would be criminal. And as he put it, his committee was concerned about hobbyists, people who might be working in their basement, create one of these things, not necessarily know the law about serialization, and so they wanted to make the first time offense especially not onerous and not criminal. But I pointed out to him that we were concerned in what they sent back to us, that it all stated in the civil for possession, even if you had done it multiple times, which seems to me just a wrong approach. So that would be,
It definitely not making a mistake if you got caught the second time.
yeah.
The same crime.
And so there are a couple of other places where we disagreed with them, where they didn't seem to have a problem with our approach. This was the only place where it seemed like we would disagree. But again, that compromise, they could live with. So the question would be, can we live?
I don't like it, but it's okay.
I feel I don't like it, but I'll.
Okay, so that would be the Senator Hushy. Senator Norris.
Don't want any part of it, don't matter.
Okay, so I suppose that would be a change that we would be looking to make before we send it back,
Okay,
is first offense being civil,
yep,
and then going back to our criminal language for the next two on possession.
so that was my question actually, was, so are you envisioning that it would be do those changes now? So in other words, not make it to this draft so that potentially everyone's in agreement with whatever
Yes.
you guys send back over.
So the idea would be that they would concur when they
When you
receive
do
our
your
further
amendment.
proposal.
Yeah.
Yeah.
And I think if we're going to do it as a strike off from you, the same
Yeah.
idea, it doesn't matter, but then they can just concur is the idea.
Yes,
Yeah. So the next change is uses.
Yes, they had, remember, uses had been what had come out of this committee. You wanted to, that's that separate crime that the committee created for using an unserialized
See, we're
firearm.
going back to Carrie's.
Going back to uses, that was your, they proposed. Kay.
Oh, we're going back to uses.
Yes.
Yeah.
And that's, so keep that, Senator Brewer?
Yep.
Okay. Let's see, page 8, that's just, well, I guess we will need to have that back in because that's just a jurisdictional piece that you need to have if you're creating a new civil offense. So I'll put that back in. Page 9, this was the issue, so now we're moving away from ghost guns.
yeah,
Next issue is the waiting period. Remember, 72-hour waiting period that applies to firearms transfers. Remember, that has an exemption for firearms transfers at gun shows, but that exemption sunsets this coming July. The proposal from the House, the House added this whole section to the bill, actually. And
But do you need the section if it's already sunset?
well, it's the policy question.
No, I understand, but our position is that it's sunset. So do you need to repeal it if it's already sunsetting? That's all my question.
No, you wouldn't do anything to that. You'd still want, I think you agreed on subsection F, which is
yes,
a separate issue.
Oh, yeah, no, I'm talking about this subsection shall be repealed.
Yep.
Do you need that language?
Yes, the language itself would stay in law, but you wouldn't make any changes. So
Okay.
it would just read as it is. If the ultimate decision is keep the repeal, have it sunset this coming July, then we would just keep that sentence.
and Martin and I have spoken on a number of occasions about that. They they felt strongly enough to put it in what they sent over, but he understands that we don't want to extend it for another year. And so, again, that wouldn't cause them not to concur if we go back to our language. And then I let him know that we had agreed with not having a 3-day waiting period if somebody brings it in to be serialized, because they already have possession of it.
Right. So now we're moving on to the issue of weapons/firearms in polling places. Right, these are the next two sections of the bill, sections 4 and 5.
Yep.
Remember, the general concept was prohibiting, well, as it came from the House, it prohibited firearms and dangerous or deadly weapons at polling places during election periods. And you'll see that this committee decided that you didn't want to have dangerous or deadly weapons in there. That was particularly given the definition of dangerous and deadly weapons. That sweeps too broadly, so you wanted to just have it apply to firearms. So that all those changes you see on page 10, 11, 12, yes, thank you, it all does.
My concern there was the deadly weapon could include a jackknife, and many people can inadvertently bring a jackknife into a polling place, and then if they were, I don't know what we're gonna do, how we're gonna find them, but if we're doing, checks like TSA, then they gotta go back out, take their jackknife, get out of line, they probably won't come back and vote.
Yeah, I share the concern that the current definition is entirely too broad, though I do think we need to come back, because I have since heard from some people, and I guess there's one town in Vermont where an individual regularly brings a sword to the voting place, and so I think we may need to tighten up the definition so that the person who inadvertently has a knife in their pocket or forgot their box cutter was, in their bag, or, I mean, as we read the definition, we had a question in this committee as to whether a dog could be considered. So I think we need to tighten up that definition down the road.
Yeah, I think probably we should look at what is a deadly weapon versus what is a.
Well, this Representative Lalonde told me that this was language that's in the no firearms on school grounds. It's in that statute, it's no firearms or deadly weapons. So they were trying to mirror. But I have agreed right along that deadly weapon just confuses the issue here. So I'll agree with Senator Bohofsky down the line. I think we could look at that. I wouldn't want to hold it up now.
No, I'm not suggesting we do it now.
Okay.
Okay.
So strike that, the deadly weapon language from the draft. So section 6, no changes. That's the crime research group's report on the offenses related to ghost guns, to get some data back on the charges filed and cases prosecuted, that sort of thing. Section 7 is the report, you may recall discussing this in committee, it came over from the House, that was looking for a report from the Secretary of State in consultation with the League of Cities and Towns and the Municipal Clerks and Treasurers Association about the issue of firearms in municipal buildings and how that should be thought about and potentially addressed. And I think what it adds, and the basis of what this committee was asking for, was to have, well, if we're going to look at that in municipal buildings, should it be looked at in terms of state buildings as well? So that's the only addition, is to add the Commission of Buildings and General Services as a consulting party and state government over on page 14. State government buildings, I should say. That's what that refers to. So that study would include that.
Eric?
Yeah.
I'm wondering why 7 isn't in the effective dates.
I believe it's a numbering issue. So there was no section 7, we got rid of section.
But I think we're putting back.
Exactly, so
So
need to
I
renumber.
thought we were
Yes.
gonna take that study out.
I didn't recollect that, but if I misheard it, it's easy enough to delete.
I don't think we need it myself.
I see no need. At this point, I've heard concerns about polling places, but I have not heard concerns generally, or maybe I will after I say this,
About government buildings.
about government buildings. It's always been unusual to me that there's really no law it's a policy that you're not bring firearms, I understand, into the State House, for example.
And state government buildings
And
generally.
state government building, but
Yep.
there's no law against it.
Correct.
Correct?
Correct.
So I think if we were going to do this, it would need to be more, involve much more than what's written here, because it does affect all areas of state government. And the only place where you can't carry a firearm under the law is the courts,
You mean of public buildings? kind of.
public buildings.
Yeah, schools, I suppose, is a public building.
Schools,
Yes, courts.
yes, but we went through a lot to define those and
Yeah.
make sure we got it right. But we've never done that with state buildings or state-owned property.
Right.
You know, I'm really worried that we're studying a little portion of this that's much bigger than the study is contemplating. Senator Bosky.
So I agree with you that the study is too narrow, and I did make a suggestion at the last meeting that we expand that to include state government buildings. That's the direction I thought we were going in, not removing it. I actually think that we should be looking into whether or not, I mean, I certainly remember the first time that I came to the Vermont State House, I was shocked at how laxed security was. And I think that with the increasing rancor and anger that we're seeing all over the place, it's only a matter of time before something terrible happens.
At, years ago, there was a security, what do you call it? X-ray. I guess, X-ray. Somewhere stuffed in the attic in the State House. And there was we had a very contentious judge hearing under judicial retention, and I believe I was vice chair. And Bill Lippert was the chair, and Bill insisted there would be no checks on people coming in because it's the people's house. So that was the view back then. I don't know if it still would be. So I think if you're going to do this, if you're really going to propose it, that it would need to include buildings, but it also needs more members. It needs members of the, unfortunately, I would suggest with members of the legislature or members appointed by leadership. The sergeant at arms should be involved, definitely, and others. Our state buildings director is fine. I think there should be a legislative, because as long as that opinion is there, and I always found it very strange that everybody's checked when the governor makes a speech. The governor's here all the time and nobody worries about him.
Right.
And we're here all the time and nobody worries about us getting shot up.
Well, I do think with the state of the state, you've got the Supreme Court there,
Yeah.
you've got all these statewide elected,
Yeah.
so it's a different
It
thing.
just feels like a little bit of,
Yeah.
here we go, but on Thursday mornings, he's up there holding an open copy.
And anybody can just walk in. I just wanted to say, I found this a little ironic because the bill where we banned guns in hospitals, when we sent it over to the House, we had a study of this exact thing and the House took it out.
Right.
And so now they've added it to our bill. So in the fullness of time, I feel like this was my position 4 years ago.
Yeah.
Still my position. So I don't have any opposition to the study. It's conducted by Secretary of State. And I also wouldn't have any opposition to putting legislators on it if that's the committee's will.
Well, I think if you had the sergeant at arms, would be probably the person that should represent the State House.
Yeah. And
Or the Capitol Police Chief, I don't know which one.
that way we don't get into per diems and
Right,
the Alice Nitka problem.
yeah, the Alice Nitka syndrome.
Syndrome. I look over at the door. That's where Alice's spirit lives.
Yes, so is that,
I think that's it.
So the only change is to add sergeant at arms to the parties to the Secretary of State consultant.
Well, to make clear, it's more than municipal buildings. It's
Government.
state buildings.
Well, state government is over on page
Okay.
14. That part is in.
Including the Vermont State House. Making sure that that's,
Explicit.
Great.
I mean, I suppose we could do it at the Bennington Battle Monument too, but I don't know. Somebody stole the. Somebody. I don't know if that's necessary, but that would be a state building. I guess, technically. All right, yes, we did that. Thank you for reminding me, we did do that study.
Yeah.
Now it's their idea, right?
Yeah. When I remember, I said, I thought it was very short-sighted of them to pull it out, but it turns out they just had a longer plan.
All right, I'm good.
Okay, and then I'm trying to remember, this might come up tomorrow. So when should we
It
vote on
comes up tomorrow.
the bill?
Yeah,
Yeah,
well,
so-
I mean, it's up anytime.
Yep, so I'm just wondering when we would,
I think that's up to the Senate Pro Tem
well,
when it gets taken up.
I'm talking about when we'll vote on the amendment. Should we vote on it in
I
advance
think
of?
we should vote on it right now.
Okay. In that case, I would move the amendment as our discussion amended it favorably.
Senator Bruce has moved the amendment favorably. To concur with the amendment, any further discussion?
I guess you're gonna know my stance on this anyways. It's gonna be no. I think this is a continuing effort to once again take guns away from individuals within the state of Vermont. And I know there's a campaign for this. There's going to be an ongoing campaign for this at some point in time. I mean, I guess that's gonna have to come to an end, but anything to do with this, I'm a no on it, so.
I'm a yes.
I'm a yes. I don't know. So it's made by, how does this work? Senator Baruch moves or?
No, it's a committee amendment. It's a committee strike call amendment.
Okay,
So-
it's Committee on Judiciary.
Yeah.
It's 3-1-0.
1-0. No, 3-1-1.
3-1-1.
Can't count.
We can check with Senator Sheen. I didn't expect him to be gone this long. I thought it was a pretty simple amendment. So that takes care of that.
And then,
It's gonna be a little while. That needs some redrafting. So
Okay,
it's gonna be
sure.
later this afternoon.
sure, and then I'll take it to the secretary.
Okay.
Okay.
I got another quote for you. I think we completed the
Yep.
control and
That's
behavior.
27. Oh, that, yeah, that's.
This is 20, this is coercion, control and behavior. Want to get rid of this,
That's 209.
209. Now we go to Eric's next bill.
Next bill, moving to another topic.
Yeah. We have a letter, an opposition, or concerns expressed by the administration from Jay Pershing Johnson.
And Jay is in the Zoom.
She's in on Zoom, so why don't we let her talk a little bit about her concerns with some of the strike law proposal that we proposed. Jay, welcome.
Thank you, Senator Sears. Sorry, and for the record, Jay Pershing Johnson, Governor Scott's legal counsel. I'm sorry I'm not there with you. I normally would like to be. It's just that I didn't want to be in the car getting there when you took this up. So anyway, thank you for the opportunity to comment on H-780, bill that would amend the judicial nominating process. I think that there are a couple of, like I say in my notes, and I won't go through my notes in detail, but so basically, I think that there are a couple of good things in here that are intended to increase the diversity of the pool of applicants, which I think is an important issue to take on. I think there's a process change. There's some other changes that are intended to do that. And our experience has been the wider the pool, the deeper the pool, the greater the opportunity for candidates with diverse experiences. That said, I just have a few concerns. The first would be, and in order of importance, that the limitation that it applies to the governor's constitutional power of appointment, which would raise separation of powers issues for me. The foundational provision for the governor's authority is constitutional in this case when it comes to judicial appointments. And basically, there is no constraint on the governor's authority to request a list from the committee that's required to be created in the constitutional provision. So basically, I had put in my notes the text from Chapter 2, Section 32 of the Constitution, but basically the governor, with the advice and consent of the Senate, fills a vacancy of judicial vacancies, basically fills judicial vacancies from a list of nominees presented by a judicial nominating body established by the General Assembly, having authority to apply reasonable standards of selection. In several states, there are constitutional provisions that apply limits to the governor's authority, but that is not the case with the Vermont Constitution. So the provision that I'm referring to is on in Section 4. Sorry, I don't have this section of the bill in front of me, but it's with respect to 4 VSA 603B, and it adds language that basically says a request from the governor for additional names pursuant to this subsection shall not be made more than once. It allows the governor to request additional names, and then it says that request shall not be made more than once. I think that this is all language that's not necessary. The governor can request additional names, has in the past requested additional names. The reasons for that are varied. And I think that, anyway, that's my concern would be a constitutional intrusion, an intrusion on the governor's constitutional authority to make these appointments. So I would just request that that language be removed. Again, I just want to support the effort to add diversity to the pool of applicants, specifically the optional nominating process in 602B2, which may encourage more applicants. But I feel that there are some other changes in this bill which could slow the process and undermine the goal of, I think, what some have noted as a process that moves too slowly. So I note in my notes here that there is history with the Judicial Nominating Board basically acting to limit the number of candidates that come to the governor. Concerned by the Judicial Conduct Board that the Judicial Nominating Board was overstepping its authority. So I think that what we need to do maybe is just continue to encourage the Judicial Nominating Board to do as it has been doing really since 2019, and that is to address the issue of diversity on the bench, to include trainings, and to increase the size of lists and the diversity of the candidate experience coming to the governor. We have slowly but surely increased gender diversity on the bench to include 50% women and includes LGBTQ plus representation. So I think that this in some ways is a solution in search of a problem, because I think that the concerns that were raised by the governor in 2019 are being addressed by the JNB. So I think that the provisions that I'm concerned about is, first of all, the makeup of the board, which adds a member to make a 12-member board with no tiebreaker, which is problematic from a governance perspective. It's already, I think when the chair of the JNB testified in the House, she noted it's already practically impossible to schedule board meetings for the 5 months of the legislative session. The addition of a new member is just one more member to manage.
Well, they did hold the meeting, I will say, during the legislative session.
They did
The
this year,
legislators
yes.
were not paid to attend those meetings, even though it was on the weekend, because we were in session.
Mhm.
And that may be part of the difficulty. I don't know. I'm not on that board anymore. what I do know historically, yes, that's correct. It's difficult during the legislative session, but I know this spent a weekend. Actually, it was
Recently.
the snowstorm, right?
I don't remember. I know it was Palm Sunday and then the following Monday, and for various reasons, I wasn't there on Palm Sunday, and then I was able to make the Monday meeting, yes, but I think in reference to, I want you to finish up before I comment on it, so you walk through whatever
I do appreciate that they did meet this year, and they got us some names for, I think, an environmental judge position. So anyway, the governance issue with respect to a tie number of candidates, of board members, I think could be problematic. I have no specific objections to the addition of the executive director of racial equity, but I do have concerns about the open-ended nature of who might be the executive director's designee. This concern was raised when she testified in the House that she felt comfortable with the designation because it's a very broad concept and really could be anybody. I think this is a novel view, and I think that it would be helpful if the legislature clarified intent. And it would be my position that the executive director's designee should be directly accountable to the executive director. Again, I think the entire purpose of the merit selection process is to strip out politics from the process. And then finally, I would ask the governor or the committee to delete 4 VSA 602E on page 13, as it could serve to further limit diversity. This is language that says the board shall consider the candidate's ties to the Vermont legal community and the candidate's familiarity with the Vermont legal system. So first of all, it's pretty well known that there is very little diversity in the Vermont bar as it is. Second, the entire process is already oriented to the selection of trial attorneys only, which further narrows the likely pool of candidates. Third, this language is really not clear. What does this mean? What are the considerations? Is it a member of the Vermont Bar Association, Vermont Bar Association committee work, VBA leadership, attendance at Inns of Court, maybe all of the above, membership in the Trial Attorneys Association? I mean, really, what is meant by this? And actually, I think once you're considering those kinds of things, you're further narrowing the pool to an already non-diverse pool of candidates. And also, I don't understand what it has to do with merit-based selection, particularly in light of the other criteria that already exist in the statute. So there is a provision in 602D, which already goes to the consideration of legal knowledge and ability, and 602D9, which is courtroom experience. So candidates have to have sufficient trial or other comparable experience that ensures knowledge of the Vermont rules of evidence and courtroom procedure. To my mind, this was probably inserted in response to objections made by the legal community. But I think for me,
Yeah, I think you're right, Senator Sears.
I'm sorry.
Senator Norris.
Yes, thank you. Yes, on page, I don't know, we've only got 7 pages to our, you're on page 13, you said at one point in time, so I don't know what particular.
And I'm sorry.
So on page 6
What we're
of our
talking about
copy.
right now is on page 6, line 10.
Right, just letting Jay know, she got 13 more pages or more pages than what we do.
Yeah.
But yes, that was supposed to be
Thank you.
taken 10 through
Yes.
14.
Both of them?
Our draft is 2:39 PM.
Okie doke. Hold on one sec.
Yeah.
I know 8.
The language is still there.
Yeah, it would be 4 VSA 602E. That's the language I'm referring to.
Yeah,
Word E.
so I have it on page 6 of the new draft, line 10 and 11.
Right.
Right.
I think we're all there now, okay? I think we found it.
Okay, great. Thank you.
Is your particular to the board shall consider Vermont candidates' ties to the Vermont legal community and the candidate's familiarity with the Vermont legal system?
Yes.
Or would you like to see both things? The board shall consider the extent to which candidate would contribute to the branch that has diverse backgrounds. That's okay.
Yes, I think it's vague. But yes, my specific concern was the board shall consider the candidate's ties to the Vermont legal community and the candidate's familiarity with the Vermont legal system. I think this is covered in the criteria above.
I remember discussing that, and I thought we decided to take it out, so.
Yeah, you may well have. The conversation about what the next draft would be took place
Yeah, I
informally
understood.
at a.
Yeah, we may have already decided to take that out, but we will discuss it again. Can I go back to the appointment of the executive director of Rachel Walden?
Sure.
And how you would prefer a intent that the person have be either that executive director or someone directly supervised by the executive director, is that correct?
Yes. Yes, I mean, that's typically what's done with designees. You know, a commissioner or designee is typically, you know, a deputy or a staffer.
Okay. I mean, okay.
Yeah,
And
my
it normally would
concern,
not raise an issue for me, except that her specific testimony was to that, the breadth of the term designee.
my concern with, and I shared this last time, with limiting it to someone directly supervised by the director is how small that office is and how much work we already put on them. You know, most of our commissioners and secretaries have large departments that they supervise as opposed to, I believe that's a staff of 3.
Well, we debate that.
And I just want to add in, I take Senator Vahovsky's point, but I do think I wouldn't want to see somebody from far outside the office named without any check on their experience or who they're representing and bringing to the table. So I think we should tighten it up somewhat. I'm not quite sure how to do that.
I hear you, but I also know that we have plenty of other boards and commissions where we use the language for exactly this office and say the director of racial equity or designee. And so it seems strange that we would move outside of the language that we use in every other place.
Well, except that this is a constitutionally required body with a very specific purpose, and that is to apply reasonable standards of selection. I don't want to start to segue this body into another sort of advisory or policy body to the extent that that's not the constitutional purpose. There are lots of considerations that the JNB takes into account now. And I think that just bringing in, say, an advocate, third party, does seem to me to be inappropriate. I mean, this could be a retired judge position, but I think that, you know, this obviously has a very specific purpose. We have to ask ourselves what that purpose is. But I mean, it can't be, or it shouldn't be any broader than reasonable standards of selection. We don't want it to become ideological purity testing. So I do think that we need to be thinking about, you know, it could be someone in the agency of administration. That's where her office is located.
That's your point.
Thank you, Jay. Anything else?
Yeah, quick question.
Yes.
Jay, does your version have, the governor shall appoint 2 members, one of whom may be an attorney at law?
Did that get changed? One of whom may be, yes, that's in your new version. Yes,
Okay,
previously it was we were prohibited from appointing an attorney.
Senator,
Jay, do you have thoughts on that? Is that positive, negative, neutral on the
I'm neutral.
standing it to allow an attorney?
I think neutral. I mean, obviously it expands the ability, you know, I mean, the universe of people the governor could appoint. But again, I think that the purpose has to be this, you know, and people, you know, responsible for applying reasonable standards of selection. Our goal is maximizing the size of the pool that comes to the governor. So I don't know. Yes, I mean, my view is neutral. We've already got lots of I mean, there are lawyers there there are legislators who are lawyers. There are obviously 3 members of the bar. I don't, I'm neutral.
So, if I might, one final question. This comes from experience, Jay. Well, our page 7 on line 3B, you were talking about if the judicial nominating board submits a list of candidates to the governor that contains less than 3 names, the board shall, upon request from the governor, reopen the search. And I think most recently.
I see what you did. Yes.
Right.
Right.
Because recently, I believe we sent 2 names of magistrates. Well, yeah, he asked for more, and we all basically voted on, reopen it. And
yes.
we're just saying.
Yes. So I really apologize. I did not see this come out yesterday, so
Okay.
I do apologize that I'm 1 beat behind you, but now I'm with you. So there are lots of. I would take out B altogether. I mean, that would be my request, that we take out B. There are no constraints in the Constitution on the governor's authority to appoint. And if the JNB sends the governor a list, the governor can request a list, or the governor can request additional names. That would be my position. This kind of provision limits the governor's authority to make this appointment. This is different than other appointments where there are efforts to constrain the governor's authority to freely make appointments. But in this case, it's a constitutional provision. And there are no constraints. The legislature
does not limit his ability to appoint.
Because it says you can only ask for 1 additional list.
But
Yeah.
doesn't the
And only
Constitution
if
give us-
it contains less than 3 names. So there are lots of reasons a governor asks for additional names. I mean, those are sort of in my notes, but the first time Governor Scott requested additional names, it was because it was for the name of a person for the Supreme Court appointment. Governor Shumlin had conducted a search, produced a list, and then it was determined that it was unconstitutional to fill a vacancy that wasn't yet vacant. So the Governor Scott used that list, but asked for additional names. That was the first time we were told by a JNB board chair that we couldn't do that. We ended up debating that with the JNB, with the help of the AG's office, and the JNB ended up asking for more names. The second time, we were given 2 names for 1 vacancy. This would cover that. The third time, we would have multiple vacancies. We were receiving names that were not sufficient to, I mean, so basically, if we had 3 vacancies, we would get 7 names. That's fewer than 2, but it's a list of 7. And what we were realizing is the smaller the list, and in the case of so in 2019, the lack of diversity on the Superior Court bench was concerning to the governor. We were receiving very few names per vacancy, and there was a lack of diversity among the candidates, because the fewer names you get to the governor, the fewer options the governor has for appointment. So it's just, when you're constraining the governor's ability to ask for more names, it's not just because the governor's looking for a political appointment. Very often it's because there are there are a number of reasons for asking for more names. It's not going to be this governor forever. And in the past, the JNB has been a problem. There's a documented history there.
I mean, at one point, when Governor Dean had an appointment for the Supreme Court Chief Justice, the Judicial Nominating Board found 1 person and sent that 1 person over to Governor Dean, trying to get him to appoint that person. He rejected that, and eventually Jeffrey Amstoy became the Chief Justice. But that was actually 1 person going over.
Yeah,
So
I mean, there are various reasons
cognizant
why.
of the problem thought we'd kind of solve the problem by saying if it was less than 3 names, the governor could continually request new. So if they tried to play that game again of actually appointing the person, so we need to discuss this amongst ourselves.
I would just, yeah, my request obviously would be to take out B. Again, primarily for the fact that there's no constraint on the governor's appointment power in the Constitution.
Senator Bell.
Yeah, I was wondering if the way to actually solve, that maybe we just need some more clarifying that it's 3 per vacancy.
I'm not sure that would take care of Jay's point.
I understand, but my understanding is that the Constitution explicitly gives us the ability to make this board and structure this board, so I don't, my understanding.
No, it gives you the authority.
Jay, I'm still talking.
I'm
My
sorry.
understanding from council is that, this doesn't fly in the face of the Constitution, so that's, I hear that that is the concern, I just don't know that I agree with that.
Do you want to respond to that?
I don't know if she understood that was for her.
Okay. Do you have
Listen to me.
anything else?
Yeah, again, I would just say that the only constraint in the Constitution is that the legislature creates a judicial nominating body with the authority to apply reasonable standards of selection. It doesn't say anything about process. And while you have established a process, which has worked well for years, or relatively well for years, I don't believe that this is constitutional or necessary.
Thank you.
Mhm.
Appreciate you making time for us and being flexible to our crazy schedule today.
Oh, no, it's my pleasure. Thank you so much for inviting me.
Welcome. So Eric, let's go back over committee, and Eric, let's go back over the changes to the bill. So on page 1, there's no problem with who, nobody has a problem with one who may be an attorney.
No, but evidently on page 1, B1, the minute we created, this seems to be the problem, the minute we created another position, the executive director racial equity.
Yeah, I was getting to that.
Okay, I'm sorry, go ahead.
Now on page 2 at the top, it's the director of racial equity.
But on page 1 it's the 12 members. Right?
Yeah, I know. So do we want the director? Do we want to and if so, do we want to put some fence around it?
What about if we allow designation within the agency of administration?
Sounds like a plan.
I don't think that, so my concern is the explicit point of this designation is to address diversity and equity, and that allowing it from, like, the other members of the agency of the administration, how would they theoretically add to that discussion?
Well, I mean, I'm assuming that diversity might include more than one person in the agency. The second thing would be, it would be a designation of the director. So the director would be making that call, who's going to represent this set of issues on this board, if not me. But I think I do have some concerns about allowing that person to designate anyone that they want to be on the judicial nominating.
I apologize, I may have shown up a few minutes late when we were discussing this part, but I personally don't see a problem with the way that it's written. I mean, I trust that the executive director is going to appoint somebody who's relevant, or who has a relevant background and understanding to contribute to the JND. I mean, from the House, it's for example, you know, they can select 3 people, but there's no guardrails except saying that,
Well, they're
only
elected.
one of them can be an attorney. Right, but, I mean, you know, for, whether it's the Senate or the House, yeah, I imagine we're going to try focusing or picking people who can provide, you know, a perspective that's useful to the JND. And I don't envision the director just picking a random person that they've never met or know nothing about. So, I mean, I trust the director to choose a good designee.
Under other administrations, that may actually occur, but I'm not really worried about our current executive director, but this is, you know, future. I would suggest that it be somebody in state government. And that way we don't have to pay per diem. Or maybe we do.
I don't, even when we first walked through the bill here, I forget who the gentleman was, but he was with, on the board, Bar Association, and they brought that as a concern. It was just too loosely written as a designee.
Was it Bob Paolini?
Bob came after, was the first,
Yeah.
gentleman.
Oh, David Silver.
Yeah, even they brought that to the forefront, saying this.
I think if you limit it to state employees, you know, maybe there's somebody that works for the Department of Corrections who'd be excellent as a designee. But I just think you by doing that, you know, in intent and purpose, I guess, Eric.
Well, it wouldn't have any legal effect if it was just a purpose or intent. If you want
Intent, then if something happened, she appointed a new executive director, if somebody that was inappropriate or considered inappropriate by the committee, that would be, you could go back to the intent of the legislature, that it be someone who, I think it goes from what Jay suggested. And other than, you know, the only other choice to get it down would be to drop one house down, which I don't mind suggesting, but I doubt the House will support it.
I think the 12 is okay if, you know, it's.
I do too.
Yeah.
I think it's an overblown problem. Generally, you're not gonna have ties on who's.
Yeah.
qualified.
And even if we do, we have the 3/4 majority, and even if that gets taken out, a simple majority.
But I'm just offering a choice here to get back to 11. We can take one house member out.
Yeah, if we're simply putting in intent, that the intent is that the appointee by the Director of Racial Equity be well-versed in that, in racial equity, I think I'm fine with that. I mean, it still does seem strange to me, like the governor can appoint anyone he wants. There's no constraint on that it be someone that reports to the governor or be a state employee, you know, so I want to trust our people that they're going to appoint the right person.
Okay, so the next,
So you want a separate intent section, that's the idea?
yeah,
Sorry,
or purpose, but
I don't understand. The present board that we have, I think, covers all of these issues. I think creating another position, not that the executive director of racial equality, I'm not opposed to that, but I'm saying we addressed all these concerns. I don't think this is going to get more of a diverse application background pool, shall we say. I don't know how it's going to improve upon that. But, you know, if you want to create 12 positions, we'll create 12 positions and go with 8 out of 12 is fine, but I guess I don't see the intent of this.
Yeah, I mean, I see what you're saying, but I don't think it'll create a broader pool. I agree with that, but I do think it'll bring a different perspective onto the board. You know, it's the thing is we don't know what we don't know, and having somebody whose job it is, or designee's job is this very specific area, which is a very important area, especially the judiciary branch. I think it's worthwhile.
I think this flies in our face. We ask these questions. We ask these questions. Another member from the House, we ask all these questions, but if it makes you feel warm and fuzzy, then let's do it.
Not about feeling warm and fuzzy.
Well, it is.
Again, it's about having a perspective that we may not have. Because again, we don't know what we don't know.
You're quoting them.
Donald Rumsfeld.
Oh, no, am I quoting Donald Rumsfeld?
Well, he used to talk about known unknowns, known knowns, known unknowns, unknown
And
knowns and unknowns.
Okay, I'm not quoting that.
I was gonna say, Senator
Close,
Hashim
it was
sounded
close.
absolutely much more coherent than whatever you just said.
it reminded me of Rummy. We don't know what we don't know.
Right,
We don't?
it's a good point.
You knew more
And we
than
don't
you talked
know a lot
about.
of things that we think we know.
Yes,
Are
that's
we
sometimes a
changing
bigger
it to,
problem.
From a majority vote to 3/4, that's okay?
Yes.
And then we have the, person may nominate another person. I don't know if I wanna get nominated by somebody else. It's sort of like saying to Lyndon Johnson, we're nominating you whether you want to or not. He was clear he wouldn't accept the nomination,
But in this process, the person still can choose not to go forward. Like they get the alert that, oh, someone nominated you,
Yeah,
someone
but
thinks you'd be a
kinda-
great judge, and they're like, no, I don't wanna be a judge. And it's done.
it's kinda. I don't know, it just strikes me as something that a little. I mean, that's sort of like philosophy on a lot of things. If you don't wanna take the initiative to do it yourself, why should somebody else do it for you?
And I understand the argument that's typically made with reference to potential female candidates for elected office that they may not feel worthy and so wouldn't self-nominate. But I feel as though by the time you've gotten to the level we're talking about, these are not reticent individuals. I think if they want that job, they are going to apply for it. And it just seems to me like it would potentially put in a lot of nominations that are essentially not going to go anywhere because the person involved doesn't want to pursue it.
One of the toughest jobs being a member of the Judicial Nominating Board, at least in my opinion, was checking all the references.
Mm.
And if you're adding numbers of people that really don't want the job, and you have to check their references, who really didn't show initiative in the beginning, and they may bow out in the middle. Senator Bowski,
So,
sure you're different.
I do feel very differently. The way that, and I haven't been on the Judicial Nominating Board, but the way that this process would happen is that nomination would happen from someone else, and the candidate would still have to apply before they would come before the Judicial Nominating Board, correct?
Right.
So it's not going to increase names of people who don't really want to be a judge to the Judicial Nominating Board. It's because they still have to go through the application, take the
Right.
initiative to go through
But
the
where
application.
do the nominations go?
To the court administrator.
Well, that's what I'm saying. So there's a flow of paperwork into the court administrator.
Correct.
That wouldn't be there if we didn't change the process.
I feel with how rampant, often labeled imposter syndrome, is amongst people, and how important we know from psychological studies and sociological studies that people see themselves represented in order to feel like they belong there. I think it's an important process that we're opening that door to say, hey, somebody in this space thinks you belong there. I do actually think that is an important step towards increasing diversity.
Why would the nomination have to go to the court administrator's office rather than just to the chair of JNB?
They came up with a process. So the idea is that the court administrator could have formed, in order to make the nomination process easy, the court administrator would put a form on the court judiciary website. Someone could fill that out, send it to the court administrator, and the court administrator will pass that along to the JNB.
So what was the JMB supposed to do then? They receive I nominate this person, does that put additional work on them? Are they gonna reach out to this person?
No, the person would still have to apply. And I misspoke. The court administrator doesn't send anything to the JMB. Court administrator responds to the nomination by providing the nominee with information about the applicant process. And then the nominee can choose whether to apply. So the
there's
J and B
some
wouldn't hear anything about it unless the nominee actually, unless
Right,
they had
okay.
the nominee actually.
I agree with Senator Sears on this one, so.
Okay. So, I'm gonna be bold, propose we take those two sections, line 10, page 3, 10 through 19 out. Lines 10 through 19 out, 2A, 2B.
Page 3.
Yeah, to take out the,
I would agree with that.
Yep.
I just don't, I think it's well intentioned, but I just think it creates an unnecessary loop of nomination.
What about page 6?
well, let's make sure we decided in the committee that there any,
Yeah, I mean, I'm feeling ambivalent for it at this point, considering the work on the court administrator. I don't know how much it would really be, but I'm fine with either. It's not a hill that I'm gonna die on for this bill.
okay? So now we go to page, we've already, I think, decided on those 5 years rather than 3.
Right.
And then we go to page 6 where Senator Norris just noted. The board should consider the candidate's ties. Jay's suggestion was to remove E but keep F.
Sorry, say that one more time, please.
She proposed removing E, that the candidate's ties to Vermont legal community and the candidate's familiarity with Vermont legal system could impact the ability for people to be qualified who of diverse backgrounds. It would limit the diverse backgrounds.
I mean, regardless of the backgrounds, though, I mean, you do need familiarity with Vermont's legal system to be an effective judge. So,
Well, we're now requiring 5 years of contiguous practice immediately preceding the application, so I feel like that should come from working in
Yeah, that
Vermont for
makes
5 years.
yeah, that's fair.
I can agree with getting rid of E.
Yeah.
And keeping F, because they seem to be in conflict with each other in a certain way.
Yeah, in some ways. So the majority okay with taking out E?
Mhm.
Alright. Now we come to perhaps the most interesting point that Jay made, but I thought we had, the question of constitutionality, I don't know. Eric, if you looked at that.
Yeah, I have a different perspective on it than Jay does. Understandable, we represent different branches in this discussion, but I think her position is a plausible one, the plausible reading of the language. My reading is different. I read the language specifically, not section 32 of the Constitution that was being referred to, which talks about the governor appointing members of the judiciary from a list provided by a judicial nominating body established by the General Assembly. I read that in the context of section 36 of the Constitution, which specifically says the General Assembly may establish procedures for the implementation of that provision. So I look at this as consistent with what is elsewhere in the Judicial Nominating Board statute, that this is another element of the General Assembly establishing procedures for this implementation of the provision. That's point one. Point number two, I look at, again, not that there aren't other possible readings, but the language in section 32, which says the governor shall fill a vacancy from a list provided by the JNB. To me, the most plausible reading of that is the JNB sends the governor a list, they make a choice from that list. And it would, if you took the position that the governor could reject a list with no endpoint, could continually reject lists, to me, that contradicts the language that says the governor shall fill a vacancy from a list provided. That would make it a may.
Yeah,
Senator Bruce.
and that's exactly right, and it says from a list, not from a series, an endless series of lists. So when I read that language, it sounds to me like it's power sharing. It's the legislature has a certain power, the nominating board has a certain power, that's to create the list. They don't have the power to pick the final choice. That's, you know, granted to the governor, but it's meant to be a balance. And if we take Jay's position, it gets rid of that ability theoretically for the nominating board, speaking for the legislature, to have any power over it, because a governor could just keep asking for lists, and that dilutes and finally eliminates their power.
Let me be blunt. Let's imagine that a future governor has a particular lawyer in mind whom he would like to appoint as a judge. And that governor doesn't get that name. How many times should the governor be able to reopen all the work that the Judicial Nominating Committee has to do until we can get to that name? And I can tell you through political circles, the name would be out there to at least some members of the Judicial Nominating Committee. But the Judicial Nominating Committee doesn't believe that person is well qualified. I think that's the reason for doing this. If we want to give him two shots, I'm okay with that, but I think there has to be an end, because the governor could do that repeatedly, you know, and not fill the vacancy. Senator Bowles.
I agree. You know, I think the Constitution sort of explicitly gives this process of the legislature shall create the board shall put names forward to the governor shall choose from that list of names. And I think you get into sort of almost a constitutional crisis loop if the governor's like, well, I'm just going to keep asking for more names till I get the one I want. It undermines the whole process that is set up. And so I think it is really important that we do, you know, I like the idea, and I'm really, you know, if it needs to be more clear that it's 3 names per vacancy, I think that that's fine. But I think it creates a real problem with accountability and just the manner in which the legislature is supposed to hold the executive branch accountable if we're just sort of saying, well, he can actually just keep asking for new ones till he gets who he wants.
I don't know why the name Billy Solesky comes to mind. Going back in history.
Yeah.
I don't have an objection to having it be 2 times. I really don't. I think that could be plausible, but it still gives an end date. You know, we're not going to keep doing this.
Just a grammatical thing, Eric. Line 4, list of candidates the governor contain. Oh wait, so that's the last one. Yeah, shouldn't that be containing less than 3 names? Governor containing less than 3 names.
I do think
yeah,
that Jay has a point, though. If there's 6 vacancies and we only give 3 names, like that's kind of the problem. So I do think a little bit more clarity around, like, you can't, that it's 3 names per vacancy.
Yeah, the same problem exists where the Judicial Nominating Committee is trying to name the judge.
Right. Like I want to put guardrails on both
Right.
ends of that process.
I'm not quite following that. The JNB doesn't send up names for more than 1 position at a time.
Okay.
It's
The
only
way,
one.
so the way it was framed, the way Jay framed it, it sounded like it was
So if
just a
there's
batch
6
of names.
openings, there's
It would be
6
6 different lists.
Well, maybe I'm wrong on that. Maybe
I mean, it depends on. I mean, there's different
Jay?
positions that we go over at the same meetings. It's not Well,
So if there
it
were
sounds like
two-
Jay,
if there were two superior judge openings, for example, might you send up 8 qualified people and that would apply to both openings?
Yes, that's,
Oh,
we have had numerous
stand up.
openings in the last few years, and that is exactly what happens.
Oh, okay.
Well-qualified people.
Great, I'm sorry.
Yeah, so this is the space where I want to make sure we're
Work with
clear
me.
that it's free per vacancy.
Yeah,
So if you're sending up a list for 2 openings, it would be required to contain at least 6 names.
right.
What if we don't have 6 names?
yeah, well, then they can make the request again,
Then they can make the request again.
because.
The governor then can make the request again if he doesn't like.
That way, it doesn't get in a space where it's like, oh, we put forward 3 names, but there's 2 openings. So really, it's narrowed the pool.
Right.
So,
And I just,
Thinking-
can I just comment, just one quick comment, is this whole idea of the loop could happen both ways, right? I mean, the game gets played both ways. The evidence from history has been that it's the Judicial Nominating Board that is playing the games, and it has been cautioned by the Judicial Conduct Board in the past, and I'm happy to provide that letter. So I guess I would say that you provide 2 names, we ask you for another name, you come back with the same 2 names, and we get to ask twice, right? I mean, it's just that the governor's constitutional duty is to faithfully execute the laws. The governor isn't, I mean, I know that your concern is the governor's abuse of power, but that has never actually been an issue, right? Again, this is a solution in search of a problem. So I guess that's just my caution is it works both ways.
Yeah, and I do want to be clear that I did make that quite clear, that I want to make sure the guardrails are both for the Judicial Nominating Board and for the governor, because I recognize that loop can happen in any direction.
Expansion.
Which is why I've suggested that we make it clear to the Judicial Nominating Board that it is 3 names per vacancy.
I'll let her get that.
Okay, so let's make a decision one way or the other on this. Do you wanna just take the section out and let the House and Senate battle it out?
Yep, I go for that.
I would vote that we leave the section in.
So I move that we take this section out and then it may be part of a conference committee or may be part of a further discussion with a proposal back to us. But the House put this in, so let them deal with it again.
I'd be fine with working on it in conference.
Okay,
I agree to that.
you got it all there?
I believe so.
So we take section, page 7, B completely out,
Yep.
except, do you need the other language?
No, it's
No,
all
we
one
don't need
thing.
any of it. Okay. I think that's probably the best thing to do, since I'm not convinced that we don't need something, but let the House defend why they put it in the first place. So, if you've got everything, we can take a vote.
Well, the intent section isn't written yet.
Oh, that's right. Okay, so we need to schedule this
Yes.
sometime.
Not more than
whenever you have-
15 minutes. Yeah, I think it'd be quick,
Okay,
or even 10 minutes.
all right.
Yeah.
Thank you. I'm not gonna take up the other bill today.
It's in appropriation, so we have time.
What's in it?
The other bill.
Expansion of approach and storage.
Yeah, I think that referred to approach, because the House had money in it. But it gives us time. We don't have to do it today, is my point. I've been tracking it and working on it, and
Well, you're the reporter.
I know.
All right, thank you, Jay. Have a good day and good to see you.
Thank you
All
all.
right,
Thank you too.
Thanks for hanging in for an extra half an hour.
Today would've been a good day to have a box of cookies, right?